You're listening to Members of the Jury, the show that takes you straight into the trenches of justice, where the passion, players, and consequences are real. Each episode, we examine current events happening in the system. From the battles in courtrooms to the streets demanding reform, we bring those stories here to you, the members of the jury, because we aren't afraid to take it to the box.
What's up, members of the jury, and happy Freedom Friday. As always, I am so grateful for everybody who is tuning in and giving the show a listen. We would not be able to produce our show without the support of our community and our listeners. And so with each and every episode, I want to ensure that I give thanks. Today's episode is going to be a policy reform discussion with a career-long law enforcement officer. And I love having these conversations with individuals who come from the other side of the aisle because I think that it allows for the audience to get a holistic picture of what the criminal justice system is currently composed of and how both sides could see the need for reform and changes to ultimately achieve the goal of having a justice in our system. I think that is the whole purpose of it. It's, in my opinion, the most critical part of the phrase criminal justice system, because you could have a criminal system with plenty of injustices, and I know I don't want that in my society, and I don't think any of my listeners want that in their society, and I can ensure that my guest doesn't want that in a society. Joining us today is Jim Carden. Jim, please introduce yourself to the members of the jury.
Hello, my name is Jim Carden. I'm a retired law enforcement officer with both state and federal experience in the specialty of digital evidence and cyber crimes, and I'm glad to be here.
And Jim, I was just so thankful for you reaching out and connecting with me online. I encourage any of our listeners who also have the same desire to see a better criminal justice system and want to have a conversation, please do so. You can email me at lhirsty@membersofthejurypod.com, or you can find me on social media at Members of the Jury or MOTJ Podcast. That's exactly how me and Jim were able to connect, and I think that it's these types of connections that are really ultimately needed to create the changes and reforms in our system that we want to have. And so, Jim, why don't you just give us a little bit more background into your experience, what you're currently doing? You indicated that you're currently retired from law enforcement, but why don't you take us to the beginning, how you started your law enforcement career and then ultimately ended up into the space that you're in now?
Sure. Well, back in the 90s, I was working as a pararescueman in the Air Force, and a fellow coworker of mine got out, and he ended up being a police officer here in California, where we're both from. And he just started talking to me about, law enforcement work and, of course, the pay and benefits that they get out here in California. And that appealed a little more than the low-paid job I was doing in the military. So I made the jump to law enforcement in about 2000. Started off on patrol, ended up going into investigations, becoming a detective. Did 6 years with the FBI on 3 different task forces that they run. Also, in my military duty, I went from active duty to the reserves. So in about 2005, I switched from pararescue and went into the Office of Special Investigations with the Air Force. Did that for a little over 11 years. And during my time of doing that, because I was doing digital forensics as a detective downtown, they capitalized on that and sent me to their defense training. And I started doing forensics and cyber investigations into counterintelligence cases that the Air Force runs. Did that until I retired from both. I started my own company called Carden Rose, still in existence. I sold my half out to my partner, so now it's just Ben Rose, but he's a great guy, does a great job. And I've been in retirement for about 5 years. I've done a little teaching during that time over in Europe with NATO forces in digital exploitation and cyber investigations. But over the last 5 years, I've really just been trying to find a new direction in retirement But you can only do so much motorcycle riding and fishing until it gets pretty old. And I'm really itching to get back into it. And I really miss the casework. I really miss helping people out that needed the help. And a lot of times when it comes to forensic evidence, whether it's digital or trace or anything else, they really can make or break a case. And so I enjoy bringing that to the law teams, whether it's defense team or prosecution or a civil attorney, because I've had a lot of experiences where it exactly did make or break the case. So.
Wow, and that's such an impressive resume. And again, I just can't thank you enough for spending time with us and letting us pick that brain of yours. As I'm sure you're aware of, in the legal realm, in the legal world, there's a lot of things that we call legalese or legal phrases that are just uniquely known to us. And so just starting off, can you give us into a definition as to what is forensic evidence?
Okay, well, as it relates to computers, it's data. So it's ones and zeros that are stored somewhere on some kind of medium, somewhere in the world, that could be related and have evidence to legal matters. No matter if they're within the state or even another country, the evidence is out there. With digital evidence, the most important thing is, one, to be able to identify it. And that's not only be able to identify what's in front of you, like if you go into a house or a building, you see a computer or a laptop or a cell phone, but also understanding the elements of your case, being able to see beyond that into what third-party servers, services, and stuff that may be involved that are often overlooked, and then be able to preserve that data correctly with legal authority. When you do identify the items, then the next step is you have to be able to preserve those items. Just like any crime scene, when we take over a crime scene, we keep everybody out, we tape it off, and you have a controlled record of everybody that goes in and out of that crime scene and what they did. Well, same thing goes with digital forensics. And we do that through what's called making a forensic image. A forensic image is just a file type that has been litigated over and over again in the courts and accepted in the courts as an acceptable way of preserving digital evidence. And then from there, after you have the preservation aspects cleared, meaning you secured the entire crime scene, not just the computer or the cell phone or anything in front of you, but looking beyond that, cell tower evidence, Google accounts, in the Google servers, whatever it may be, gather all that evidence and then be able to go through it, being able to look at the big picture of your case and see what weight that digital evidence can hold in your case. Sometimes it doesn't hold much. Sometimes it holds a lot. And I think that's really important, especially for attorneys, to understand at the beginning of their case, not at the end, just before trial, which I find a lot of the times is when I'm brought in is a couple months out from trial. But really being able to have that understanding at the beginning, I think not only helps investigators out, but also can help attorneys out. A lot of my time as a forensic investigator, I was assigned to work with other investigators on their cases, whether they're homicide detectives, white-collar crime detectives, robbery detectives. I would support their investigations, just like I supported the DA's office and criminal defense attorneys in their investigations with the digital evidence aspect.
And I know with digital evidence, probably the number one issue that both prosecution agencies and defense teams face is that oftentimes when you're dealing with especially digital forensic evidence is the voluminous nature of those types of files and evidence. From your perspective and the unique ability of sitting now on both sides and working with, prosecution and defense teams, aside from just the volume issue, what would you say each side's secondary issue in dealing with forensic evidence would be?
Volume is definitely an issue. And I also, it's a tactic that I've seen among different attorneys to what they call do a data dump on one side to overwhelm them with volumes of evidence. That is an issue, but that's easily managed if you have the proper digital evidence support, working with you. What would overwhelm maybe an attorney who doesn't have training in that area is not going to overwhelm someone like me who works in that area routinely. The other aspects that I found that were work to the detriment of one of the legal sides is the lack of understanding and the depth of digital evidence and how to utilize it in court and how to actually line your questions up as an attorney, not only with the questions that you might be able to pull out of a report, but what about the questions that aren't in the report? How going beyond what's reported into the depths of the digital evidence. A lot of times I'd have attorneys ask me direct questions about the digital evidence that I located in a case, but they didn't follow on with how did I corroborate that evidence? Was there evidence anywhere else involving that supports what you found in the computer? And those are the questions that usually lacked when I was in court. I would get asked by attorneys about what's in my report, but in a lot of times it wouldn't go any deeper than that.
And so, like, in your retired life away from law enforcement, and dealing with now just this expertise of forensic digital evidence, do you find yourself predominantly working with only defense teams, or even as a retired law enforcement, are you still reached out to by prosecution teams as well?
I have not worked for prosecution teams since I left law enforcement. The company that I helped run, we did mainly civil litigation and defense work. My partner, Ben Rose, was primary on all defense work. That was his specialty. I did more corporate IP theft, some family law, and in other areas. But when Ben would get overloaded, he would ask me to take some of his cases for him to help him out, which I did, which is my limited experience with criminal defense. And every case that I helped him with, the DA actually dropped charges. They never even went back to court, because once the digital evidence was exposed and the DA was able to see it under another light, they realized that they were maybe going down the wrong path on that case and had the wrong person, or the person's innocence would be shown in court when the jury trial starts. And so they just dropped the cases.
Well, and that I think to me highlights a really critical part of essentially the system, because what I am taking away from that is, and obviously thank God that person was able to retain you on that case, but take you out of the equation. Because not everybody, unfortunately, whether it's with the public defender's office or private attorney, is going to, one, have the resource of a connection to a forensic expert. And even if they do know a forensic expert, they might not be able to afford them. So I'm just curious, like, if you weren't involved in a picture, what should somebody do when they find themselves in a digital forensic heavy type of case? Aside from try to contact you or some other forensic expert.
That's a really difficult question to answer, because it takes someone with expertise in that area to do. An attorney can have the awareness, but if they don't have the background and actually how to take action, then there's really not a whole lot you can do. But what an attorneys can do is, one, preservation letters sent out immediately. One of the first things in all our cases, especially civil cases with high profile like IP theft cases, is we recommend our attorneys immediately send out preservation and put the other side on notice that we are looking at digital evidence and you're duty bound to preserve that evidence. Other than that, then if they don't have a forensic expert helping them, they just need to go through and try to identify digital devices and then try to preserve that evidence in a way so it can be brought in later. And one technique of doing that preservation is just getting those devices, bag and tagging them, start the chain of custody, throw them in a safe somewhere. Don't even touch them or turn them on, but just literally segregate them from everything else until you could have a qualified person come in and process and deal with that evidence for you.
And I want to quickly go back to one of the things you had just mentioned about how, in a case where you were retained, basically because of your ability to interpret the forensic evidence differently than essentially the detective or law enforcement individual on the case. What was it in those cases that like ultimately led to the dismissal? Because in my experience, in order for a case to get dismissed, you have to have pretty clear cut controversial or contradicting evidence. Because if it's a close call, a lot of times in my experience, prosecutors will say, well, let's just take it to the box and let a jury decide. And so I just, it's especially in that type of situation, it seems like you would have had to have such a different interpretation of the evidence than essentially the law enforcement on the case. And if that is true, what does that say about that case essentially being filed in the first place?
Well, I mean, to give you examples, and I've had ones where, the attorneys are always looking for that smoking gun to make their life easier in a case. And a lot of times they go through the regular investigative modes of investigating physical evidence and everything else. But when the digital evidence isn't investigated properly, they miss their smoking gun. It's there. They just haven't seen it yet. One case that I did, for a defense attorney, he had a client that was locked up for about a year on charges of kidnapping, domestic violence, sodomy, among a few other serious charges. When the cops came to the crime scene, they collected the digital evidence and put it in their vehicle and took it to the police department in the form of tablets, phones, and laptops. But they just put it in the evidence room. They never looked at it. Their case seemed to be pretty clear cut to them that digital evidence really was not going to add anything to these, physical crimes of physically taking someone against their will from place to place, holding them in a house or a motel against their will and committing sexual assault on them. They had the victim, they had her statements. They had a SART exam done, which was positive for the evidence in that. And they were happy with that, and they were ready to go to trial. The defense attorney, who was an attorney that worked with our firm regularly on civil cases as well, reached out to us and asked us to help them. We had relationships with these attorneys, so we were more than happy to help them. And we examined the tablet in that case. And what they didn't know at the time is this woman who was traveling around with this man regularly installed an application on his tablet so she could do her text messaging through his tablet. And so she didn't have to use the phone or whatever reason. Well, no one ever thought of that, noticed it, or even looked into it, obviously, because it was an unknown in their case. When the defense attorney took me to the police department and we got the evidence and we forensically imaged it and everything there at the police department with the detectives present. And we analyzed that. We found that when the cops took the tablet, they never shut it off, which again, or put it in a Faraday bag, which are two common standard procedures for collection of digital evidence. So they really didn't follow those rules. That actually worked out to our client's benefit, because while that tablet was en route to the police department and sat in a police locker still on, it had a cellular signal because it had a SIM card in it. And as the victim was texting her friends and family, all that was registering on the tablet. And what we found out is the incriminating statements, I guess, that the victim made is that they just arrested so-and-so. He'll never cheat on me again. I taught that, SOB a lesson. Basically, she set him up and she made it up. And it was very believable. She went to a lot of great lengths to, have this evidence and like the SART exam evidence. She kind of set him up in that regard. So, and these were very poor people. They were almost homeless per se. They lived in motels a lot of the time, had zero resources. But when we examined that tablet, the own victim statements, I mean, if you can imagine, how those would look in court, we sent those to the DA and the DA just dropped the charge. It was a no-brainer for them at that time. And the guy was released from jail.
That's fantastic, because especially in those type of cases, I mean, even with that, I'm surprised to see that a dismissal being the result of the case. I think that's fantastic, and I think that's an excellent example of how your services and your expertise can play a substantial role in a case, even when the crime in and of itself isn't necessarily dealing with, a forensic or white collar, commonly known as a white collar crime. And, that actually got me thinking, I feel like despite us living in a world of technology in 2023, where literally, almost all aspects of your day-to-day lives are micro data collected on some device that you have around you or near you, I feel like there's still so little known and spotlight on, digital crimes, or in this, and now, like you're indicating, almost digital, I don't want to say like alibis, but like digital defenses. What's your view on the digital space and its intersection with the criminal justice system now that we live in such a technological advanced state?
So the way I look at digital evidence is your best unbiased witness to your case. The computers and the cell phones don't care about any of your biases. They just record data. And that data is there, and it's there for a very long time. Even if they delete it, it's still going to be there most of the time. So you have an opportunity to go in and you get both sides' statements, and then you take the digital devices and see, well, which statement does it support the most? And that's usually more closer to the truth. So that's the way I view these devices, as witnesses to your case. And in so many cases, they never talk to that witness. And that's in 2023, that is, in my opinion, negligent. You need to. It's vital to someone's freedom, or to a victim who's looking for a prosecution too of the right subject. These are vital statements that are made into these digital devices. So that's the way I look at it. And if you're not looking at the digital devices, it's the same thing as not talking to witnesses that have information for you about your case. There's no difference.
I think that's a fantastic point. And I think that it's such an educating and enlightening conversation because, yeah, as I'm sitting here, me personally, I'm almost caught off guard by how little knowledge there is. And to the point you made earlier in the podcast, that like there's essentially aspects of criminal cases where people have where, the Constitution gives them the right to an attorney. And that doesn't necessarily, in that type of situation, unless the attorney has the wherewithal to know that they need a forensic expert. And I think what you've illuminated to me is that there could be a benefit to retaining a forensic expert, even when the case isn't, like we talked about, a white collar one, or one that deals with kind of digital crimes, because that could still have so much impact on a case. I think that sexual assault case is a great example. And, we had an opportunity to speak off camera leading up to the show. And one of the things that kind of continued to circle around our conversations and the aspect of education and reform was that notion of fairness, because the prosecution agencies all across the country are, riddled or full of law enforcement officials who, like yourself, have that training and have the advanced information to know how to look for crimes digitally, or even corresponding evidence in a non-digital case. But the defense side doesn't necessarily have that counterpart. And fortunately, we have individuals like yourself who in 2023 are making that movement. Why don't you take a minute to speak to that and your desire to create fairness in this justice system?
Well, with the public defender's office, and people are required to have competent and effective lawyers. And that's in the constitutional part of the criminal defense. But that has to also be an extension of those who are helping that lawyer. It has to go down to the forensic experts, to the investigators they're working with. They have to be just as competent and trained as I think the attorneys are. And where I kind of find that there's a disconnect is that the DA's offices are a lot more staffed and have much higher budgets than I think that the defense counsels do. I looked in my county, And in my county, the DA office has 22% of the county budget, and the public defender gets a little over 8%. They literally have 1/3 of the budget, but yet they're handling near probably similar caseloads, because every time the DA files, most people are probably going to use a public defender. I mean, some that have money, it's nice, and maybe they could afford their own, but I think the caseloads are pretty similar. So I think that's just part when it comes to fairness, is something we need to look at, not just through the legal communities, but as society as a whole, on, what is fair and what is fairness. And is it fair to take an attorney that has some of the most highly trained people in the country? Meaning, when I did my forensic training, I was sent to almost 2 years of training through the California Department of Justice Advanced Training Center in digital forensics and investigation. And then on top of that, because I was also working on the federal side, I was sent to the Defense Training Investigations Academy out in Maryland to also get more advanced training. Well, I don't know many public defenders that probably have the budgets to send their people to the same type of training. So in my short involvement with the public defender's office, this is something I've noticed and just really doesn't sit right with me. Even as a detective, when I worked in the police departments, I always ensured fairness. I've even had one case that was kind of interesting, where I had a shooting where a guy was shot about 9 times on the street. And the only witnesses were these 3 ladies that were in the area. On top of that, we had the shooter, right before he did the shooting, got in an verbal argument with someone on the street, and decided to shoot him 9 times. He was in a liquor store making a purchase. So we had really good, clear video evidence of what this person looked like. So we're working our case, working our leads, and this even has nothing to do with digital evidence, but with fairness. We get a tip that we recognize the guy in the video, and here's his name. So we go and we look into that person. He is an exact fit. If you look at him and you look at the video, 9 out of 10 times, everybody's going to say that's the same guy. That's how close. Same hairstyle, same facial features, everything. So I did a photo lineup and took it over to the victim or the witness, and we did it, and she positively identified this individual. And I always had them go through it. And I said, okay, mark an X on who you identify or recognize. They do that. And then I said, put a percentage on your confidence level. And it's perfectly okay to be 50-50 or even less confident. But what's your confidence level that this is the guy that did it? She put 100%. I ended up doing a search warrant and going into the house looking for the gun and making an arrest. The kid ended up being a 17-year-old juvenile. And we had to arrest him and book him in juvenile hall. Well, I did my investigation on this guy, and I did a lot of questioning and interrogation with him as well. And I believe that he didn't do it. All the statements he gave me, even though by recognition, facial recognition, it seems to be a complete match with a 100% ID witness that was there saying it's a complete match. His story and the evidence weren't jiving. I had to spend 2 weeks out of my case actually doing the defense investigator's job, going after this guy's alibis and proving that he didn't do it. So as I had to arrest him, he spent 2 weeks in juvenile hall. I also went and unarrested him and made sure the DA dropped all charges against him, because even though we had 100% identification, he was a lookalike. He was one of those, what they call doppelgangers for the TV show. And so, we had to weigh the evidence and it just didn't support him. So I think fairness is essential no matter what stage of the process we are. And I think the fairness in the defense is critical. And I really have a hard time, or really not okay with the attorneys not having the level playing field of the same level of expertise on both sides. And that's why I decided I wanted to volunteer and help defend criminal attorneys in their cases, because I have the time, I have some of the resources, and I just think it's a good way to help the community out.
Level the playing field. I absolutely love that. And I'm going to circle back to that because I do want to give you some time to highlight those services, the platforms that you've created and that fight for fairness. But one of the two things that kind of popped into my head while you were giving us that contextual story. And that's one, like, over the course of time, I think that we've seen in the criminal justice system and realm, especially essentially coming from the prosecution and the state government and things like that, is this notion of, at times, especially in new areas, what turns out to be junk science. I think one of the best examples that I can think of that is, if you're familiar with Ted Bundy. Ted Bundy was tried, and in one of the cases, they presented evidence of a dental biting or something like that. And after the fact, it came out that actually the science that was presented was not actually scientifically reliable, and therefore falls into the category of junk science. Now, I'm interested because, computers and digital things, they're responsive to human commands. And so I was just wondering if in your experience now dealing with both sides, if there was any aspect of junk science that you would say exists when dealing with different types of digital forensic evidence.
No, I really don't have anything in the regards of junk science. I think that we all have, in law enforcement, you're given a lot of tools, and the tools can be effective if they're applied correctly by someone with the training and experience in applying them. Now, I think they can be misused and misapplied in a lot of cases too. So, it's not the tool that should make your case. Whenever I did a case, I would prove it using different methods, that I was trained to use and was within our policy of using at our department. But I always try to prove my case at least 2 or 3 different ways. Meaning, if one stream of evidence gets thrown out, I have another stream or 2 to fall back on. Because when you're looking at evidence, it's usually not existence in a vacuum. There's usually corroborating evidence that corroborates the evidence that you most powerfully want to use in your case. And so it's important as an investigator to go those extra steps and corroborate your evidence in several different means. And as a forensic expert, when I used forensic tools, I don't rely on those tools as being completely accurate. I will do an investigation in my favorite tool. I will call out all the evidence that I think is inculpatory or exculpatory and label them as so. But then I go back and redo that investigation at least 1 to 2 other tools to see if I get the same result or not. And if I don't, then I have to investigate why that is. I haven't ran into they don't. Usually they do, because the tools we have these days are very sophisticated and they're under a lot of scrutiny in courts, at best, especially in the federal level. So they're pretty reliable. But that's normally how I tackle it. And I don't ever try to rely on one aspect or one evidence. I'm always trying to have corroborating evidence that supports it as well.
Jim, I just want to tell you that in the 2 conversations that we've now had, obviously one of them wasn't recorded. I just think it's so commendable to speak with someone who has the background that you do of prior military service, which obviously thank you for being a veteran, and law enforcement, who has such an outspoken desire for justice and fairness. I think that it's so easy for an individual to get engulfed in their side and put on tunnel visions and only care about the outcome that's best for them. And so it is really refreshing to have that type of conversation and mindset coming from another individual, especially with one who has the background of yourself. And, and that just goes directly to your project. And so I want to, for the members of the jury listening, Jim is retired and is offering his own personal and private services. He is open for pro bono work. He's open to helping out public defender's office. And he's also willing to, if you want to retain him as an expert, there are service-based fees that do apply. And so, Jim, why don't you just give us an intro into what is the Charlie Delta Project and how it came about?
Well, the name Charlie Delta comes from my military service. When I worked in the Special Operations Command on different teams, when we had our inter-team radios, we all had call signs we went by. My tactical call sign was Charlie Delta. So, and I actually loved that job. I did it for over 10 years. It was like the best job I've ever had. So anyways, that's kind of where I pulled the name from. But then I incorporate my law enforcement experience, and really it is just about bringing fairness, where digital evidence has been either under investigated or improperly investigated. Just like any other type of evidence, that happens. And so I like to, look around into the case, review the case files, kind of identify, in my opinion, if evidence was either not investigated at all, like in the scenario with that tablet, or under investigated. What I mean by under investigated is digital forensics, you could have a whole spectrum of expertise in this area. And you have guys that are extremely experienced and good at it. I have my mentors in the field, that I don't even come close to, but I strive to. And then you have people that are brand new to it. And a lot of times when you're brand new, you get what we call push button forensics, where you don't do a lot of in-depth work, but you let the program kind of cull through and pull the data out for you and kind of just produce reports to attorneys. And in cases like that, you could definitely tell when you read the reports, you can tell whether the investigator did a pretty in-depth job, or if they kind of just are going through the motions and using the software more than their own intellect and investigative ability. And a lot of times I think that comes with a lot of departments that are extremely busy, so they're just processing these cases out thoroughly as they can, but also as quickly as they can. And sometimes, especially if the attorneys really don't know the difference between a really good forensic report and one that's kind of canned and generated through the software, how are they to know? They just go with what they're given. So, that's where I think I could come in and help attorneys, is just in a case evaluation. And that valuation is more into what aspect does digital evidence play in your case, and what weight does it hold in your case? And, if I go through it and I find the smoking gun, well, then great. I could let the attorney know, here's what I found, and they could be like all gun ho, let's go to trial, or, with this evidence, it's pretty clear, or if it's the opposite and it's actually inculpatory, they might want to have a long talk with their clients, like, let's get you the best deal we can, because if this comes out in court, which it will, it's probably not going to go in your favor with the jury. So I think it's a great tool, and the service I provide could help attorneys in just really navigating digital evidence and making a decision in that regards. Since I am starting this out, and basically it's self-funded, I don't have anybody funding me for this. I have very limited equipment. I don't have all the equipment that I was able to have in my own business or working at the police departments. But that does not stop me from doing case evaluations, looking at the reports the officers generated, and just giving the attorney, here's what I think with your case, and here's the directions I would go. And they could seek out people with the right equipment maybe to do that. Or whatever they need to do. But I think it can be an assist, to the attorney in moving their case along.
I absolutely love the desire to, balance the scales of justice and, fight with fairness and being the front line, because that's the essence of the criminal justice system. It's supposed to be fair. The outcome should be just. It shouldn't be about just winning the case. And so to hear that you've already in limited experience as essentially for extensive purposes, a defense retained expert, the fact that you've already been able to have those success stories just based off your little involvement, I think shows to the type of caliber that you will be able to have as you continue to be involved with it. And I think that does, and it's showing that your role can play a huge role in providing fairness and justice to cases. Anybody who is interested in learning more about the Charlie Delta Project or Jim just in general, or the different services that he provides, I would highly encourage them to check out charliedelta988.com. You'll be able to find that link provided in the show notes, and that will give you full access to Jim's background, the different services that he provides. Those we've highlighted a number of them already in the show, but other services that are included are digital crime scene reconstruction, file recovery, timeline analysis, file system and database analysis, and metadata analysis. And metadata can play such a huge role in cases. I think if anybody is familiar with the Serial podcast and that first case involving Adnan Syed, they would have heard so much about the information in the cell towers and the metadata that surrounded that, and that ultimately I think played somewhat of a role in his exoneration 20 years later. But Jim, as I was reading through your website, one of the things that I think sounds to be most influential, especially given your background in your desire now into helping the defense fight on a level playing field, was this notion of helping attorneys form lines of questioning for trial and cross-examining opposing experts. What is it about your prior background and experience that you think would now allow you to help essentially poke holes in people who are doing your job now?
Well, two things. I have a lot of time on the stand. When I worked patrol, I came from the military, from the special operations community, where we are pretty aggressive go-getters and we love our job and we love doing what we do. So when I was a young patrolman, I was very proactive in making arrests, and a lot of them. That meant I was going to court a lot, and means I got a lot of experience under questioning and cross-examination from both sides. And you learn a lot in the box, so to speak, or up on the stand. So I take that, and I also take my experience in advanced training that I got through the Department of Defense and through the DOJ and my work with the FBI, and I'm able to see who is a better expert than other experts. Like I said, we all come to this work with different levels of expertise, and we all have to begin somewhere. So sometimes I'll come across and it'll be a newer examiner, and they do a decent job, but there's maybe a lot of holes or things that they didn't go into that they should have, that I don't see in their report. So some of the reports are literally cut and paste cannon fodder from standard language used, in different types of reports. I mean, that is the biggest tell sign if the person's really experienced or not, because when you have someone really experienced, it shows in their reports. So really just coming in and looking at the other expert, looking at their resume, looking at their training and background to determine how much experience they got in actual being an expert witness and investigating crimes. And, I think just going from that really is can help out an attorney. And then being able to help them with the questioning, with taking, from the other experts' reports, if I do see areas that there's gaps or lacking depth, then we can go down those roads in the questioning, because that's where you want to hit at. Like I said, when I was on the stand, usually they would address issues in my report. And believe me, some of those times I was pretty nervous because, I put this in my report and I believed it was true, but, maybe it was when I was newer and younger, I didn't do as in depth as I would do now. And I'm just hoping, praying they don't call me on that aspect, and they didn't. And I think that goes with, the depth of questioning, and with attorneys that don't have an IT background or a big digital evidence background. That's where, I can assist in helping formulate those questions, looking at depths, and not only the depths, but in which directions then you can do follow-on questions to those, to elicit more information, to get to the truth in the matter.
Well, and I think that service is so huge, because it's one thing to understand something, it's another thing to present it, but at the end of the day, if a case ultimately goes all the way to the box and to trial, the thing that's going to be the determining factor is how the information comes out and how the jury understands it. And, part of being a lawyer is having to wear multiple hats and not only understand the law, but understand, aspects of now forensic evidence, and being able to present it in a way that is understandable and digestible. And so I think, me personally, that service, it stands out above all else, because that is really what's going to allow the defense to be on par with the prosecution, or especially with the forensic evidence expert, because, if you're not able to speak to them in a way in which you can show, like, look, any attorney who tries to become the smarter person of an expert is always going to lose. But being able to understand what the expert is saying and maneuver that through your questionings to then, in closing or later, explain what all of those questions means is going to have the upper hand. And, I think that's where a lot of times defense lacks it, for various reasons. We can't have fundings to maybe call the expert themselves, but, where funding lacks, it could be a beneficial alternative to say, like, well, I might not be able to retain or call my own expert, but I have had the opportunity to consult with an expert who has reviewed some of the same evidence, and through talking to them, devise a plan of good cross-examination questions that would poke holes in the state's or experts' case in chief, and then allow for a more level jury deliberation, as opposed to just one side being able to present all of this kind of unchecked, type of science. And so I think that the services that you're providing are a huge benefit to the criminal justice system as a whole, to the defense bar, both public defenders and private attorneys, and would love to see more individuals who do have that type of both sides background play an intricate part in leveling the playing field. And so, Jim, as always, one of the last question that we always propose to our guests is, what is the significance of taking matters to the box?
Well, for me, it's about fairness. It always is. I'm not on a team. I work as an investigator to ensure that the truth comes out. And I think that's what we're all seeking. And when you take it to the box like that, that's where the rubber meets the road. And we're really playing with two very volatile situations, both the victim and the person on the other side of the courtroom. One has had a crime committed to them. The other one is about possibly losing their freedom if they're guilty of that crime. So I think in our country, and one thing that makes our system so great is that we don't presume their guilt until the judge reads the verdict. And so until that point, we got to give everybody the equal opportunity to show their innocence. It doesn't do anybody any good to put the wrong person behind bars. That is an injustice. And what it means is, not only did you put someone behind bars, but the actual person that's out there committing those crimes is doing it to someone else. And so how do we get more victims? And so that's my philosophy and why I do what I do, because I want the actual responsible person to have to pay the price, whatever the courts deem that price to be, for acts they committed. And I don't want to see innocent people or people that were set up or anything like that have to, pay for a crime that it wasn't their intent to do, or they didn't do at all.
Hashtag bring back the presumption of innocence. I'm definitely a firm believer of rather seeing 100 guilty people walk free than one innocent person be wrongfully incarcerated. And so I really resonated with that statement. I want to thank you so much for joining us today, for just sharing your background, your little bit of knowledge into the space, offering your services. I hope that this has been educational and informational to the members of the jury listening, for a resource for us to fight back against the almighty powerful government and all the resources that they have, because as Jim indicated throughout this episode, it's never about just winning the case. It's about ensuring the right outcome, the justice outcome comes, and that fairness, that right to a fair trial is truly fulfilled. Well, members of the jury, that's our show, and I rest my case. Be sure to come back next episode as we take another matter to the box. If you're a fan of the show, go ahead and subscribe. You can also find us on social media at Members of the Jury. If you want to be a guest or have any feedback, be sure to email us at lhursty@membersofthejurypod.com. The information in this podcast is provided as general reference work as a public service. The audience is advised to check for changes to current laws and to consult with a qualified attorney on any legal issue. The use of this material does not create an attorney-client privilege in any fashion with the podcast, the host, or the guest. This information is for educational purposes only, and no one affiliated with the podcast may be held liable for any decision made based on this information.